Good evening and good morning. So today we have a match for the Inter-University Law Debate Tournament 2026, ninth edition between McGill University and the University of Nairobi. So two teams who are now in the round of 16 stage of the competition. So they'll be debating on a topic they received a week ago. But now I give the floor to my colleague, Ms. Urbanova, for hosting the match.
Thank you very much, and good day and good early evening to the students joining. Welcome to the round of 16. Well done on passing to the second stage of the tournament. Your topic for today's debate is whether or not platforms must implement privacy-preserving age assurance for high-risk services. As always, before we start the debate, I would like to invite students for introductions, starting with Mr. Kitui of University of Nairobi.
Sorry about that. Hi everyone. My name is Paul Kitui. Fourth year, a law student at the University of Nairobi. It's been a pleasure interacting with everyone in the tournament, and I'm excited for today's match. Thank you.
Welcome, and thank you. From McGill University, Mr. Ribeiro Toy.
Hello, everyone. My name is Samuel Robertoy. I'm a law student at McGill University, and I've so far had a tremendous experience in this tournament, and I wish everyone the best of luck today.
Thank you. Welcome, Mr. Irungu of University of Nairobi.
Good evening from Kenya. My name is Ian Irungu, and I am also very glad to have made it to the rounds of 16. And I'm looking forward to the debates today. Thank you very much.
Thank you. Welcome. From McGill University, Mr. Haddad.
Morning from Montreal. My name is Joe Haddad, second year law student at McGill University. Really excited for this debate.
Thank you. Welcome. From University of Nairobi, Ms. Baraza.
Hi everyone, my name is Jane Baraza, again from Kenya, and it's a pleasure to be here. Nice to see our host and our moderators, and as well as the opposing team, and I'm looking forward to having an interesting session today as well. So thank you.
Thank you. Welcome. So in a few short moments, you should be able to see the wheel for the allocation of your positions for today's debate. If I can just get a confirmation. Yes, thank you. 4 possibilities, 2 for each team in favor and against. And for today's debate, it is the team of McGill University that will be defending the against position. Thus, the debate will start by debaters of University of Nairobi defending the statement that platforms must implement privacy-preserving age assurances for high-risk services. You now have 5 minutes to finalize your preparations. Feel free to close your cameras. Thank you, everyone. This marks the end of your final preparations. Just a short reminder, you will be getting visual cues in regards to your speaking time, so yellow for 30 seconds, and when you see red, your speaking time is over, but you can still comfortably conclude your last sentence. And thus, without further ado, now passing the floor for the opening statements, starting with the in favor position. You now have 4 minutes.
Good evening, members of the panel. Just as a preliminary issue, just to confirm that I am audible.
You are.
Thank you, members of the panel. Now, with the rise of technology has come new ways to access information and to spread awareness across the globe. But with these benefits of access to information through technology come new novel risks that affect the most vulnerable sections of our population, some of them being children. Now, the motion before us today asks that platforms must implement privacy-preserving age assurance mechanisms for high-risk services. Now, straight off, it is necessary for proposition to identify what their burden is in this situation. First, we need to show that there is risk, that certain online services do actually create serious, foreseeable harms and risks for minors. Second, that there's a responsibility on platforms. This is because platforms are not merely passive or neutral. They actually design, rank, recommend, monetize, and optimize user experiences, and therefore should have the responsibility of regulating what is on their platforms and regulating access to their platforms from certain demographic groups. Third is that there's a legal foundation. Existing law, as we will show, does increasingly impose child safety, privacy by design, and risk assessment obligations on platforms. Fourth is feasibility. We are going to show that privacy-preserving age assurance mechanisms are not science fiction, members of the panel. They are technically possible when implemented, and they can involve data minimization, attribute-based credentials, trusted third parties, and other methods that are not injurious to the privacy or the safety of children. First, we should identify that there are legal grounds to impose age assurance mechanisms that are privacy-based in order to protect children and minors from high-risk services. We look at the UN Convention on the Rights of the Child, passed in 1980. First, we do acknowledge that there is Article 13 that provides for the right of freedom of expression of the child, which also includes the right to seek, receive, and impart information. However, members of the panel, we do know that this is tempered by Article 16, which provides for the right to privacy of the child, as well as Article 19, which requires that children be protected from all forms of physical or mental abuse, mistreatment, or exploitation, which can definitely happen in online platforms, which sanction communication, messaging, and interaction between children and unknown adults, or platforms that provide services such as pornography, gambling, and other such high-risk services. Therefore, we do know that there's a legal obligation on states to actually adhere to the protection of rights of children as enshrined under the UN Convention on the Rights of the Child. There is also a consistent line of jurisprudence, members of the panel, in jurisdictions of note such as the EU and the US that show that the right to freedom of expression can be tempered by the right to privacy when it comes to children. We look at the case of KU versus Finland, where the applicant was a 12-year-old and somebody posted an advertisement of a sexual nature on an internet dating platform without their consent. Now, while the platform's rules provided for anonymity in order to protect the freedom of people to express their speech, the EU court, the European Court on Human Rights, stated that the right to freedom of expression enshrined through confidentiality in platforms has to be tempered by the positive obligation on states to impose legal frameworks that protect children, even in these platforms. The same thing happened in the US in the Free Speech Coalition versus Paxton case. Here, just last year, the US Supreme Court made a decision that where there are laws that impose obligations upon websites to verify the ages of users in order to prevent children access, then this cannot be defeated by a claim that right to freedom of expression is going to be violated. This means that there is a temperate obligation on states to impose positive legal frameworks that protect children, even in the face of the right to freedom of expression. Seeing as my time is up, I will cede the floor to the opposition, and I shall leave my colleagues to proceed on arguing this motion. Thank you very much.
Thank you. Now for the opening statements for the against position, 4 minutes.
Thank you. Members of the jury, one thing is undisputed. children deserve protection online, and digital platforms can expose them to real harms. And international law increasingly recognizes that children's rights must be protected in the digital environment. But not every protective measure is justified. Now, the issue before this jury is whether platforms must implement privacy-preserving age assurance for high-risk services. We submit that they should not. Online risk does not automatically justify mandatory age checks, even when framed as privacy-preserving. Let me begin with a few definitions. When we say must implement, we're referring to mandatory legal obligation, not a voluntary safety feature. And this matters because a mandatory obligation would affect not only children, but all users who may be required to prove or signal their age before accessing online services. When we say privacy-preserving age assurance, we do not deny that the systems may be less intrusive than others, but we submit that the label privacy-preserving does not eliminate or eradicate the risks of surveillance or of future misuse. And when we say high-risk services, we recognize that some online services pose greater risks than others, but the category remains broad and unstable. If interpreted expansively, it could include social media, search engines, gaming platforms, video sharing services, AI tools, and other spaces that are very important for expression. To defeat the motion, we will make two submissions. First, I will submit that mandatory age assurance risks creating surveillance infrastructure and undermining the rights to privacy, anonymity, equality, and access to information. Second, my colleague will submit that age assurance is an incomplete and disproportionate response because it targets access rather than the harmful design features that create many online risks. Each submission will be asserted following the IRAC method, that's issue, rule, application, and conclusion. So my first submission is that the system as presented by the proposition team will risk normalizing surveillance and undermining privacy, anonymity, and equality online. The opposition references the Convention on the Rights of the Child, and they cited it as, protecting children's privacy. General Comment 25 of that convention confirms that children must be protected online, but it also warns that children's rights to privacy, access to information, and freedom of expression must not be undermined by protective measures. And when we combine it with the proportionality principles under international law, a measure that interferes with privacy must be necessary, it must be suitable, and it must be the least restrictive means available. In application, mandatory age assurance may appear limited, but it can still require digital checkpoints using government ID, biometric estimation, third-party verifications, or device credentials. And these systems may create records of access to sensitive services. For example, privacy concerns were raised about THIULDT, a major age verification provider. And that was done after researchers reported tracking risks, and Spain's Data Protection Authority fined the company for GDPR violations involving biometric data and retention. So this shows that even privacy-preserving systems can create privacy risks in practice. Once this infrastructure exists, it can also expand beyond high-risk services and be repurposed for, as I said, surveillance, profiling, exclusion. And this is especially concerning for marginalized users. Children without stable documentation, migrant children, refugees, disabled users, or young people seeking sensitive health. Therefore, the motion should be rejected. Thank you.
Thank you. We have heard the opening statements. Now proceeding to hear the first rebuttals, starting with University of Nairobi for the in favor position, 2 minutes.
Right. Just time myself as well. Right. So I'll start on my next word. The first thing we'd like to clarify from proposition is the scope within which this debate functions. Now, just to clarify, you've gotten a rather broad categorization of what this debate ought to be from opposition, which is not accurate. The motion is within high-risk services, and this doesn't mean that it has to function within a wide scope. It can work when tailoring the services to certain specific high-risk services, the case from proposition and from the first speaker did not encompass the generic characterization that we get from the opposition. Therefore, in that instance, all of our desired impacts will still happen in any case. But then there's a conversation around feasibility and why, in response, and this is also an implicit response to the argument on privacy and why privacy will not be violated. This is where we introduce the zero knowledge proof mechanism that has worked for so many companies and continues to work in status quo. In a nutshell, you have a trusted privacy protecting technical infrastructure which only tells the platforms if somebody is above the required age and nothing beyond that point. Therefore, it only provides the bare minimum that is needed without exposing the data of a certain user. And this is mostly done by third-party actors. Third-party actors, and certain examples are like Apple's declared age range feature, or sharing an existing age credentials on a certain user's device. And this has happened across multiple platforms, and certain apps have incorporated these features. For instance, THIULDT has been mentioned. Instagram has incorporated THIULDT for face age estimation, and it has a 99.3% success rate between 13 and 17-year-olds, and successfully being able to police any access to this platform that may otherwise be illegitimate. So this zero knowledge proof is the guaranteed mechanism that will make this work. Thank you.
Thank you. For the first rebuttal in the against position, McGill University.
Sorry, I couldn't turn my mic on for a sec. Members of the jury, age assurance may look like child protection, but the only thing it's doing is shifting the symptom. It's dissimulating the symptom from the disease. The problem is not simply that children are high risk users. The deeper problem is that many of the platforms are built to extract attention, extract data, and extract engagement from vulnerable users. They are designed to keep children scrolling, clicking, sharing, reacting, and a child can prove that they're above a certain age, but that doesn't limit the infinite scroll, the infinite autoplay, the infinite manipulative notifications targeted towards them. So the legal question should not be, can the platform identify a child? The legal question should be, what is the platform doing for the child? Because otherwise, we are just putting the burden on the child himself and not the corporation. And that is exactly what the Supreme Court of the United States said in Free Speech Coalition, a case that the opposition has cited not on one, but on two occasions. Free Speech Coalition v. Paxson does not change that. Because at most, what the Supreme Court of the United States is teaching us is that verification of age may be tolerated in a narrow context. A context where access is limited to adults and where not restricting it would directly put the corporation in breach of its criminal duties. But the motion today is not about that. The motion today is about platform design in situations that might otherwise be legal. Age assurance is under-inclusive because it regulates entry and not conduct. Once the child is inside, the architecture of the site stays the same. And the third-party verification that the opposition has just cited doesn't help that. Because what the third party is only doing is doing the job that the corporation would nonetheless have to do, which is verify the age of the children. And that should trouble us, because the better answer is not to build larger identification. The better answer is to regulate harmful conduct itself. Thank you very much.
Thank you. For the second rebuttal in favor, University of Nairobi.
Reduce your sound here.
Thank you. I will be starting in my next. The second speaker for the team proposition has clearly stated that what we are doing is that apps are designed to just sustain engagement and extract data. However, that is just a false mischaracterization of what the motion essentially entails. because the motion clearly states that platforms must implement privacy-preserving age assurance mechanism for high-risk services. So it's not just about wanting to extract data, it's about ensuring these platforms are suitable and they're able to protect their users as well. But one important aspect of the privacy-preserving age assurance mechanism is that it is offering dual protection. The first thing is privacy-preserving to only keep a section of your data, and it already satisfies the whole principle of data minimization, which has been clearly alluded to by several regulations that I will refer to this particular panel as I continue. But again, secondly, it's on age assurance. So they're also guaranteeing safety for those who are also interacting with these platforms. But most importantly, I would like to direct this honorable panel to a February 2025 statement on age assurance that was issued by the European Board of European Data Protection Board. And it clearly mentioned several principles, including fairness, transparency, accuracy. But most imperative, there are two particular principles that essentially align with what privacy protection age assurance mechanism offers. The first principle is the prevention of data protection risk. And this can only be attained when there are no loopholes, which is more likely to happen when you're having different alternatives that the opposition bench needs to essentially engage and demonstrate how it's going to ensure like these particular trickle-down effects of not having proper security mechanisms are going to be protected. But the second principle in itself was that it needs to have purpose limitation and data minimization. Panel, this is what privacy preservation age assurance essentially entails. It is able to ensure, one, securing those who are essentially using these services, but at the same time, not able to have the trickle-down effect of having the users not feeling safe about their data essentially being rippled out. And that is what privacy preserving age assurance offers. Thank you.
Thank you. For the second rebuttal in the against position, McGill University.
Thank you. The proposition's strongest argument is that platforms need visibility into age to protect children. But visibility is not protection. A platform can know that a user is a child and still expose that child to addictive design, as my colleague rightfully noted, to manipulative advertising, to harmful recommender systems, or to commercial profiling. The real issue is not simply whether those platforms know the user's age. The real issue is whether the platform is safe by design. And international law does not require us to build digital checkpoints in order to protect children. It allows and indeed encourages regulation of harmful platform architecture directly. Therefore, the lack of age visibility cannot justify mandatory age assurance where less intrusive safety by design measures are available. Furthermore, the proposition says that the duty applies only to high-risk services, but that category leaves a lot of discretion to states with respect to implementation. Today, it may mean pornography or gambling. Tomorrow, it may include social media. It may include gaming, video sharing, AI chatbots, search engines, or even educational forums. And many of these services are not sources of risk. There are places for expression, there are spaces for learning, support, community, and for vulnerable children, including disabled youth or children seeking mental health or sexual health information, age gates may block access to important resources. So the broader the category becomes, the more states could weaponize the motion to limit lawful expression and access to information. That is why mandatory duty is dangerous. It begins with extreme cases, but it can expand into ordinary digital life. Thank you.
Thank you. We have heard the two rebuttals. I'm now proceeding to hear the concluding statements, starting with University of Nairobi for the in favor position.
Members of the panel, one thing that is readily apparent from the opposition speeches is that there is a slippery slope argument that implementing privacy-preserving age assurance mechanisms for internet-based applications and information will lead to a slippery slope where there will be a surveillance state and restriction of freedom of information as well as freedom of speech. However, members of the panel, we urge you to look at jurisprudence and cases that have already considered this, because yes, members of the panel, this is a balancing act. On the one hand, we have the right to privacy of children, and on the other hand, we have the freedom of expression and the freedom of access of information. However, in all cases, even in the case that we have cited and that they have rebutted, which is the Free Speech Coalition versus Paxton case, the courts have considered this issue. They have considered that yes, the freedom of expression and the right of access to information is a fundamental right. The First Amendment is the First Amendment for a reason, members of the panel. However, on the other side, the right to privacy, specifically of children, is one that cannot be simply that cannot be passed over, members of the panel. This is the reason why we have a UN Convention on the Rights of the Child, and that the rights of the child are not simply subsumed into the greater legal regime on the rights of persons. Therefore, members of the panel, we urge you to consider that the rights of the child, the best interests of the child, are of fundamental importance in any discussion about a balancing act between the right to privacy of children and the right of access to information and the freedom of expression. Members of the panel, once again, we have shown that privacy-preserving age assurance mechanisms are feasible, where they actually preserve the privacy of the children, as well as prevent them from accessing harmful and illegal content. We do note that THIULDT has a 99% 99% positive rate. This means that it can identify the correct age 99% of the time. This is privacy-preserving. There is no need for upload of ID, only AI technology in verifying the facial features of the subject. Therefore, this is a valid alternative to any alternative methods that might be intrusive on the privacy of the child. And we assert that this motion should be carried. Thank you.
Thank you. For the concluding statement in the against position, McGill University.
Sorry, my microphone didn't turn on again. Members of the jury, vulnerability is not binary. A 15-year-old is vulnerable the same way a 75-year-old is vulnerable. So anyone with low digital literacy is vulnerable. And age assurance only puts them in two categories: minor or adult. But harmful design doesn't exploit in this binary way. It exploits the very specific data of each person. Age assurance cannot be defended by narrowing this debate, like the opposition did, to high-risk situations, and then pretending that the mechanism is totally neutral. The issue is not how much data is collected. The issue is why is the data collected, who controls the system, and what is the legal architecture that we are trying to normalize. My friends say third parties, zero knowledge proof, data minimization, bare minimum disclosure. But that doesn't answer the deeper question here. You cannot separate the goal of the data from the data itself. These platforms are not public guardians. Their business model is going to be to collect, classify users, and then use that classification to exploit their business. And data minimization is not the magic phrase. A minimized surveillance is still a surveillance system if it becomes the condition for participating online. Zero knowledge might reduce what is revealed in a single transaction, but it does not exclude chilling effects, circumvention, or error. It does not stop a platform from saying, we now need age assurance for this feature and this consent at this service to this interaction. And that creates a trickle-down effect. Another argument they propose is that the government should look at what everyone's doing, but that is contrary to common law principles of constant positive obligations. We, however, submitted two arguments: that age assurance is incomplete due to disproportionate rules, but also that it's the surveillance infrastructure that should prime. Members of the jury, the question is not if age assurance can sometimes be more private. The question is whether it solves an issue, and we submit that it does not.
Thank you, everyone. We have heard the concluding statements from both sides of the argument. Well done to the two teams. You can all now relax. You're no longer graded after this part. Congratulations on completing your debate in the round of 16 in this 8th final. Well done. Honestly, it's been a pleasure seeing your first debate all the way up to this debate today. Of course, a big thank you to our 3 international judges that, of course, have the time to review the match, perhaps already are watching live on YouTube. As soon as our organizing team has validated the scoring cards, we'll be sharing them with you, and you will be knowing which team proceeds to the quarterfinals. and will be facing actually the winner of the match that took place just before this match, about 2 hours ago. So the winners of your two matches will be facing off in quarterfinals. Of course, there is a possibility that you meet or in other areas of your future careers, but already now I would like to pass the floor to my colleague, Mr. Sanchez Cortez Macias, for the feedback round of today's debate.
Thank you very much. First of all, congratulations on today's match. I hope that you are proud of your performance. And, well, as you know, I would like to collect your feedback, whether on the topic research or the match itself. So for this, I will first give the floor to Mr. Irungu, sorry.
This is definitely the most interesting and intellectually stimulating round I've had so far. Again, just as with previous rounds, I guess we're all on the same page about the arguments that we had, and the only difference was whether we preferred arguing for proposition or opposition, and that came out very clearly in the arguments that we were bringing forward and the attitude that we had in presenting those arguments. So I definitely had quite a bit of fun. I mean, as we all know, this is a topic that's very current, and so I think it's of interest to each and every one of us. So a very nice and interesting round.
Thank you very much. And now I give the floor to Mr. Haddad.
Thank you. Well, again, I echo everything that was said. I agree. And the interesting thing about those motions is that you could interpret them as, okay, we're going to like create a new international law principle that will then have to be implemented by states, or we could just see it as, no, this is how everything should be. So it's definitely interesting to kind of see how different teams look at those motions and translate them into concrete terms. But yeah, it was a great debate, great motion, and yeah, I had great fun.
Thank you very much. Now I'll give the floor to Mr. Kitoi.
Yeah. So hi everyone. Again, without sounding redundant, I really enjoyed today's debate. Personally, it was fun. By far, objectively the most interesting round I have in terms of digging into the research. I think the jurisprudence around this subject matter, what the courts have had to say about it, is actually very relevant to what we deal with every day. But at the same time, it's so unexplored because the paradigm of the internet changes every day. There's always something new that the law has to address. So it's not as static as most other topics. So it was definitely fun to see what the courts have had to say about that and dealing with how quickly everything is changing. Yeah.
Thank you very much. Now I will give the floor to Mr. Ribeiro.
Yeah, I think they kind of covered everything. Uh, I think that the topic itself was written in a way that was very broad, which made it perhaps difficult to anticipate what the other party was going to plead. And I think the topic is so complex that I personally had difficulty arguing in 2 minutes because there's so much to be said, and kind of not only what you have to say to make your argument work, but you also have to try in some way to take from the other person's argument and try to weaken the argument, which I found that was very interesting. But I think the timing constraint of the way that the debate worked made it a very interesting, perhaps summarizing activity here. So I think it went well.
Thank you very much. And last, I will give the floor to Ms. Parazza.
Thank you. So for me, it will just be to reiterate basically what everyone else has said. I think fast researching the motion gets to unravel a lot of what we probably would bypass and not really pay much attention to, especially when it comes to what mechanism is used in being able to like ensure age restrictions are well secured, even in different platforms, talk about Netflix and even the other research, just every other platform that exists. But I think just to echo what the most recent speaker has said, it was really difficult to really have a niche on what specifically to focus on because it was really fragmented. You're trying to look at the private aspect, you're trying to look at the age assurance aspect and how they all integrate. And you basically cannot do everything. You just have to look at what has the other person said that could probably be a weakness and try to find loopholes. But basically, I'd say it was a really interesting motion to prepare for, and it was really nice to go against the University of McGill for this one. So yeah, thank you.
Thank you very much. Thank you everyone for sharing your thoughts and your feedback on today's topic. And now we will proceed to the networking questions. So first of all, what opportunity, program or initiative of your university has most contributed to your development as law students? So for this question, I will floor to Ms. Baraza.
Sorry for that. Personally, I'd say my moot court society and the University of Nairobi. I think it's an opportunity where you not only get to learn how to do research in itself, but legal research in itself and learning how to argue and integrate it within argument. So I think learning how to probably integrate those mooting skills, but at the same time, I'm part of a debate society and we usually argue in the British parliamentary format. So obviously the timings are different. We usually argue in 7 minutes, but here you only have to do it in 2 minutes. So probably learning how to compose yourself and be paced through moot, as well as oral advocacy skills that I get through debate, merged together has basically built my capacity in being able to participate better in this particular competition. So that would be my response for that.
Thank you very much. Now I will give the floor to Mr. Ribeiro.
Yeah, I think I think my mooting was the most important part of law school. I think, right, if you go to law school, it's because at least if you want to litigate here, you're in Canada or I think the States too, probably everywhere. You kind of separate into two different types of lawyer usually, either transaction or litigation, and I mean the private sector. So I think mooting because I want to be a litigator was the most interesting activity just because it teaches you not only how to dissect a problem but also how do you frame the problem so that a judge actually agrees with you, even if sometimes your problem is morally very wrong, but you have to defend a morally wrong position, but you still want the judge to sleep at night, right? So I think mooting showed me how can you frame something so that not only it's legally sound but is also morally acceptable. And so yeah, so I think that's what made me, I think, a better future lawyer. And so yeah, I think that's it.
Thank you very much. Right now I will give the floor to Mr. Kitui.
Yeah, so just like Jin, definitely debate and moot. Beyond the hard skills that debate obviously gives you, for me, I'll additionally look at it from a soft skills perspective. So I've been in charge of a debate club for quite a long time. It's been like 3 years or something. So you definitely have to learn how to deal with people's problems as well. They come to you with challenges that are non-debate related. You have to resolve, a lot of personal clashes. So there's an EQ aspect to it that I've gotten to appreciate. Dealing with your administrations and their demands, balancing it with what like your people expect from you. So like a lot of patience as well has been nurtured beyond the hard skills that took me to debate in the first place. Mooting as well has been good. I have been fortunate to do both of them at relatively competitive capacities, which is where I met with like these two guys. So I met Ian through mooting. Okay, I didn't meet him through mooting. I knew him slightly before, but I got to know him properly through mooting. There's a moot we did that was very extensive for like 7 months of like a lot of research. So you don't go through that suffering without like bonding at the end as well. And Jane has been my long-term partner for debates. So I think all of that together even speaks to the team that we have. For me, it's just a perfect blend of the both of them, culminating in something that can apply all of the above. So I would say definitely 110% very impactful. Yeah.
Thank you very much. Now I will give the floor to Mr. Haddad.
Yeah, unlike my colleagues, I do not want to be a litigator. So I'm more interested in like the transactional side of the practice. But there's still a lot of things or a lot of activities, a lot of opportunities at McGill Law that do prepare you to be a better jurist, to be a better um, lawyer, whatever you want to do. And my colleague rightfully noted the mooting. And the good thing at the faculty is that we can get non-course credits, so we can get credited for mooting. We can also get credited for clerking with a judge, which is also a great opportunity. We get I also was a teaching assistant and I got credited for that. So there's like all sorts of opportunities to get credits and move on in your degree while gaining that practical experience. And I think that's really useful because it's most conducive to private practice. But yeah, besides that, academically, we have McGill Law is renowned for its transsystemic approach to learning. So we do, in the same class, we get to learn about civil law. So the Quebec Civil Code, which is very similar to France, and the common law, British, of British origin, and so we get to compare them in the same class, and in the context of contract law, in the context of tort or extra contractual liability. So it's definitely been a great experience. It's changed the way I think, but yeah, I think being a jurist is really cool, and I enjoy it.
Thank you very much. And last, I will give the floor to Mr. Irungu.
I definitely don't have much to add on my previous colleagues' statements. I obviously think mooting is the best platform. I'm just very surprised to learn that you get credits, academic credits for mooting at McGill. We would sorely appreciate that over here because we get nothing for mooting. That's just an individual adventure we go on with our colleagues, and yeah, we just do it for our own self-fulfillment, and like there's no reciprocal intervention from the school. So it's great that you guys do have that recognition at McGill, and I just think it would be an amazing experience over there because mooting is without a doubt one of the most formative experiences when training to be a young lawyer. I mean, you can do all of the coursework and the theory, but mooting sort of gives you a platform to actually argue out principles of law, to actually present arguments, to build strategies in a real life simulated court situation. So kudos to you guys for having a very progressive law faculty that can do that. And yeah, I would definitely like to study law there, and also because of how you guys are at the intersection of two different cultures. Because I don't know how true this is as of now, but I know that there's a Quebecois movement where you guys want to secede from Canada because of your French-leaning cultural roots. So it would be very weird because Canada I know has majority common law leanings, and then Quebec has civil law because of like the inheritance from France. So yeah, I just think you guys you have a lovely time over there. Yeah. Anyway, that's all from me.
Thank you very much. For the second question, I will give the floor to Ms. Olganova.
Thank you very much, and thank you for the teams for sharing. Before passing to the second question, just a short highlight. Your teams are quite well matched in this round of 16. For both cases, it's the first participation. It's the first time you have directly went to the round of 16, and you have made a mark on the ranking of the World League of Debate through the Hagen University Law Debate Tournament. Of course, the final ranking will be released in June, but already University of Nairobi will be placed on the African zone of the ranking, and of course the world one, and the McGill University for the North American zone. You have both won 2 matches so far. This will be added on by your successors in the next edition. And just a very brief second question, because we have another match to start shortly. What are the nuances or perhaps misconceptions about your legal system that you would like to share or maybe shine a light on a bit more? So perhaps first to the McGill University. But again, just a very brief, we have another match in a few minutes.
I could go, Joe, since you're a transactional lawyer and you don't know the law. No. So, like you talked about Quebec, and it's kind of interesting. One thing that people don't know is that every province applies common law except Quebec that applies civil law, but Quebec doesn't apply public civil law. So we only apply civil law to private things. So, for example, for what's criminal, what's constitutional, that's about it. We'll apply common law to those principles. However, our common law for criminal is actually a code, which it kind of makes it weird because we apply common law with a code for criminal matters, which is something that people don't know, but that's interesting to know. So even if you're trained in civil law in Quebec, you still somewhat understand how common law works, simply because for constitutional matters and criminal matters, it's still common law. Anyway, that's briefly something that's very interesting about Canada.
The same goes for civil procedure too. So even in Quebec, civil procedure follows the common law adversarial model, which is very interesting to see.
Thank you. And now passing forward to University of Nairobi.
Okay, so I think our misconception is largely the same because there's a misconception because we were from a British colony that we've imported wholesale the common law system, but surprisingly, from 1960, over 50 years of independence, we've developed so many codes that this could be identical to a civil law country, but like nominally we're a common law system. However, we have civil law codes, just like you have, for example, we have a penal code for criminal law. We don't rely on the traditional law conceptions of crimes such as murder, manslaughter, etc. So even for commercial transactions, again, we have our own law of contract act. So I don't know. It's a common misconception that the UK sort of propagated their common law system throughout the world. However, over the past couple of decades, a lot of us have simply transitioned to codifying a lot of these legal issues, and so we resemble more of a civil law system than a common law system. So sometimes, officially you'll see that, okay, Kenya is a common law system, but when you actually try to look through the law here or practice law here, you'll find a lot of it is civil law. Yeah.
Thank you. Thank you very much to both teams for sharing. It's quite exciting. I believe you have a few common topics, not just the a really good progression for the first side in the tournament to connect on further, but also in your student activities and of course in the legal systems. We do encourage you to stay in contact. I know already University of Nairobi has met other participants prior, so perhaps a tradition to keep continuing. All right, we'll be closing off today's debate. This is actually the final match of the round of 16. So if you haven't caught the previous matches, I really encourage you to do so. The winners of this debate will find out shortly. Thank you again to the 3 judges. Really well done, everyone. It's been an honor and pleasure. Well done.
Thank you, and see you soon. Bye bye.
Thank you, everyone. Have a good one.
Goodbye.